Morning, class. Hey, it's Mr. Stewart, and this is coming into week 14. We are on definitely the downhill slide in the course at this point. So today I'm going to take a few minutes to talk to you about premises security liability. And you're probably hoping that you would get through this course without being told all the different ways that you could get sued. Well, that's not going to happen because that's what today is. When we talk about liability, what we're really speaking about is do you have a safe environment for your employees to work in? Do you have a safe environment for the public to come in if you have a publicly open facility? And are you doing everything you can do to maintain the facilities to be reasonably safe? Now, we need to talk about the definition of reasonableness for just a minute. Reasonableness can be defined in layman's terms as if you were to present the same set of circumstances to any Tom, Dick, or Harry out there on the street, would they likely come up with the same decision or as you did? And so that's really what the test of reasonableness is if anybody else would have likely done the same thing you did or made the same decision as you did. Things are unreasonable when you do something really way out in left field or you do something that most normal people just wouldn't do. So make sure you understand this concept of liability that's listed on, it talks about it on page 265 of your textbook. And it really has to do with the ability for someone to sue you in civil court for monetary damages. Liability does not necessarily occur in the criminal realm, and you're typically not going to go to prison if you're found civilly liable for damages for something. But you may have to pay, and you may have to pay a lot of money. So just understand that the basic principles of premises security liability are important today because we live in such a litigious society. People will sue you at any time for anything. And the lawsuit doesn't even have to be valid. It can be fraudulent, and it's still going to cost you money because you have to have counsel or at least some resources to defend that lawsuit. I'll tell you a quick story. My dad was the executor of my grandfather's estate, and when my grandfather passed and they decided to sell his farm and sell his house, the guy that bought the house, it was a 4-bedroom brick home on 5 acres. It wasn't that old. I think it was built in 1960 or 61. It's not that it was a hugely old home, but it had some problems like any older home would. It needed some wood replaced in the floor and some things like that. Well, when the home was sold, and it was sold cheap, it went for $37,500. Where can you buy a 4-bedroom brick home and 5 acres of property for $37,000? I don't know. Anyway, the home and the property sold that cheap. It was announced at the auction that the property was sold as is, and prior to the sale, they made multiple announcements on auction day. Go inspect the home, because when you buy it, you've bought it, and you bought it just as it sits. Well, there was a guy bought the property, and about 6 weeks later, the deputy sheriff shows up at my mother and father's house, serves them with a lawsuit. The guy is suing them for $55,000 because he says that there was some mold in the home, and he's going to have to go in there and do almost $20,000 worth of work to remediate the mold, and so he wants a free house and free work on the house is what it amounts to. He wants to get his money back on the house and pay for all of the work that needs to be done on it. It was a fraudulent lawsuit. It was a frivolous lawsuit because he bought the house as is. It's kind of like you buy a car from someone as is. There's no guarantees. There's no nothing. He had the opportunity to inspect the premises. He did not, and I think he was probably a sore loser. Well, this thing went on, and it cost my parents about almost $6,000 to defend this lawsuit, and it was dismissed. But it cost almost $6,000 to defend it up to the point that it was dismissed. So even though it was frivolous, it still can cost you money to defend it. So the best way to avoid lawsuits relating to security on your premises is to make sure that your premises is safe. Make sure you're doing everything possible, everything reasonable to have a reasonably safe location for your employees to work and the public to come into if it's open to the public. Make sure that you're familiar with the concepts of duty, breach of duty, injury, and causation as it pertains to the security of a premises. Now I'm going to talk about duty for just a minute. Duty is the legal responsibility requiring a property owner to maintain reasonably safe premises. You have a duty to maintain those reasonably safe premises, either through the application of security procedures, through security practices, security systems, whatever, or a combination of everything that we've talked about up to this point in the course. Put that all together in order to maintain that reasonably safe premises. Breach of duty is probably one of the most easiest understood of the reasons why people sue someone over premises security liability. This is when you should have done something and you didn't. There was a breach in your duty. Breach simply means failure. It's failure of defendant in a civil action to perform the duty that was imposed either by law or when assumed voluntarily. So let's say that you run a restaurant and the restaurant has a tile floor and you have mopped the tile floor. If you don't put out the little sign that says wet floor and somebody slips and falls on that floor, that's been a breach of duty. You should have put the sign out there to warn people that, hey, the floor is wet and they might slip and fall on it. Slip and fall incidents used to be one of the more common things that people sued other people over. So, I mean, we've kind of got away from that at this point because people are taking those steps. They put out those signs and they warn you. If you go through McDonald's and you get coffee, on the coffee cup it now says, caution, hot. Like, duh. You go get coffee, don't you expect it to be hot? Unless you order iced coffee. But that arose out of a lawsuit where a lady spilled hot coffee on herself and caused some very serious burns. She sued McDonald's, won a lawsuit. McDonald's appealed that and ended up getting that decision reversed, but they decided they would warn people from then on because they thought, well, it could be construed as a breach of duty if we don't tell people. I mean, it's kind of like the little sign on the hairdryer, don't use the hairdryer in the bathtub. Would you believe that they probably wouldn't have that sign if it had not happened? I mean, seriously. Drop the hairdryer in the bathtub, it's going to shock you and it's probably going to kill you if you've got water in the tub or the shower. I mean, who seriously would use a hairdryer in the bathtub? I don't know. But that's just one of the things that happens. So when you see those warning signs and things like that, that's people trying to avoid a breach of duty lawsuit. It's pretty simple to avoid those things as long as you take reasonable steps to maintain reasonable safety. And you cannot foresee every single thing that can happen. But if you're taking steps to ensure the reasonable safety and reasonably safe premises, then you shouldn't have any major issues. Injury in the legal context includes the more obvious physical injuries one may suffer as a crime victim, as well as less obvious mental trauma frequently resulting from an attack. Injuries also include financial losses sustained from damage to property. So an injury is any injury that you receive, whether it be physical, emotional, psychological, or financial. It's really simply some sort of a loss. And causation simply means what was the cause of the loss. And if the causation can be linked to you or your security policies, practices, or procedures, then you're going to be liable for that loss. So just understand that. Now we're going to talk for just a minute about foreseeability. I told you just a minute ago that you cannot foresee every single incident that happens or that could possibly happen at your facility, but you could and you can foresee many possible incidents. Really what foreseeability is the risk. What is the likelihood this is going to happen? Could or would a reasonable person have been able to foresee or reasonably expect that the issue might arise? And the way that you go about determining foreseeability is looking at your risk factors and maybe prioritizing them in likelihood of occurrence, or most importance, or possibly both. And the ones that are more likely to occur and will cause the greatest number of losses, those are the ones that you need to try to address first. And then even the ones that won't cause a great amount of loss but could possibly get you sued anyway, and it's foreseeable, that's the things you also need to address. On page 269 in your text, it talks about a concept called the totality of the circumstances. And what that really is speaking to is when you are determining premises security, you need to look at the big picture. Because what we as humans do, we like to drill down and be very, very specific on a lot of things, or we like to talk only in very general terms. But the big picture perspective is the totality of the circumstances. You may have a security procedure in place. You may have a security practice in place that you think is pretty good about preventing losses and therefore will protect you against liability. Well, if we go back and we look at it from the big picture perspective, and we think that what you're doing is really only a drop in a bucket, then you still could be deemed liable because you're not doing enough, or there was more to the story than simply the couple little things that you foresaw. So make sure that you are familiar with that concept of totality of the circumstances. And part of the totality of the circumstances, it looks at previous history. What things have you done or have you not done in the past? Have you been sued before? What was it for? Did you win? Did you lose? I mean, all those things can be admissible in civil court where they not necessarily would be admissible in a criminal court. So make sure that you back out of the very specifics and also look at the big picture and try to approach it from a perspective that other people who don't know the business could look in and say, wow, this person was really running a reasonably safe location, or this person was really fouling up. It was a wonder something didn't happen before it did. Because that's also what's going to help protect you. Because guess what? There's not going to be security experts on a jury trial if you get sued. It's going to be Tom, Dick, and Harry, or Sue, from out there on the street, and they're going to look at it from the big picture perspective because they're not going to understand the specifics. So just remember that totality of the circumstances concept. All right, risk factors. Risk factors are things that you should look at when we are determining the totality of the circumstances, when we are determining how safe you are from liability or how vulnerable you are from liability. I mean, a lot of times we look at prior crimes at the site, crime history of nearby areas. I mean, think about it. You may not have had an incident, but if you have a lot of crime in your area, you need to take some steps to make sure that your employees are safe, that somebody off the street doesn't come in, so that crime that happens 2 blocks down doesn't bleed over into your facility somewhere. So crime history of the nearby areas. And also you need to look at crime in similar facilities or businesses. If you run a fast food restaurant, the potential that somebody could hold you up right before closing time is very high if that has also happened at other locations. What about prior complaints? What are similar incidents that have happened in the past? And understand that you must have a knowledge of crime, and you must acknowledge that there is inherent risk. Everything you do has some risk to it. We cannot get rid of every single risk. Now, we can mitigate risk, and that means lower that risk, and we can get it to a level where we can manage it. But there's always going to be some level of risk. I mean, if you get out to drive to school in the morning, when you get in your car and you pull out of your driveway, you're taking on a risk. Now, what you've done is you've transferred that risk to an insurance company. If somebody hits me or I have an accident, then my insurance company is going to cover me. And maybe you also have medical insurance. So if I get hurt, then my doctor bills are going to be paid, or at least some of it will. That's what we call transfer risk. Now, you can't transfer all risk. I mean, the thing about it is you could still get in an accident. Your car's still going to be torn up, and you could still be injured. It's just a matter of the financial losses might be diminished because you've transferred the risk. That doesn't mean you're not going to have pain and suffering, mental anguish, or psychological issues or whatnot. But there's every single risk we cannot transfer or mitigate. Sometimes we just have to take it on and hope for the best. All right, for just a minute, let's think about some of the plaintiff's theories behind liability issues. On page 272 and 273 is where this section is. The first one is defective equipment or devices. What we're talking about here is many times you will get sued if you put out a piece of equipment that's defective. It doesn't work, or it doesn't work the way it's supposed to work. I can tell you another story where my dad, when he was a young man, worked at a manufacturing facility that made bicycles, and he used a big metal stamping press, and it had a piece of safety equipment on it that if you didn't get the part in there just right, sometimes when it stamped, it would kick it out and it could hurt you. And a lot of times, the way it was designed, it could take a finger off. Or if your hands were in a certain location, the press wouldn't come down, and it came down really quick, like this. It was a stamp. And if your hand was in a certain spot, it was supposed to keep that press from coming down. Well, my dad was working at this factory running this machine, this piece of equipment, and the safety features failed on it 2 or 3 different times, and the press came down on his hand once. Luckily, there was another piece of metal beside his hand, and so the metal took the force. Now it mashed his hand, but it didn't break anything. So, but he said, "That's it. They're either going to fix it or I'm not working here." And they said, "Well, we didn't think it was that big of an issue." So he quit. The guy they hired to replace him got his hand chopped off the next day. So just understand that if you have a piece of equipment that your employees are using, that equipment better not be defective, because if they get hurt, you are liable for it. Deterrence theory. Deterrence theory cases are those where the plaintiff asserts that the assailant would have been deterred from committing the crime had certain security measures been in place at the time of the incident. Under this theory, a claim is asserted when, for example, the plaintiff is assaulted in a parking lot in an area where security has not been patrolling regularly. If you have a big parking lot and it's not well lit at night, or it doesn't have a fence or a security guard or a patrol or something to keep maybe would-be assailants from hiding in the back seat of a car and maybe raping someone or assaulting someone at some point. So you are supposed to also take reasonable steps necessary to deter crime from happening. And if you don't do that, then you are liable. I mean, this even applies to, let's say you're running, a Subway. There's a Subway down the street from the Huntsville campus here. Well, there's one down the street from Decatur campus too. Let's say you're running a Subway, and let's say the Decatur campus at 9 o'clock at night, I would say that Subway is pretty well deserted because campus is empty. The GM plant is now closed. There's not a lot of traffic stopping in that area. It's also not a lot of light in that area. It would be a prime target for somebody to come in and rob late at night. So what many businesses simply do is they look to see when their business is falling off, and they just simply close. They say, okay, we're going to close, 8:45, or we're going to close at 9 o'clock, and and we're going to go lock the door while we close so nobody else can come in and think about robbing us or doing something else. So, I mean, by doing that, you have deterred a potential criminal from coming in and trying to rob the closer. Another thing is what many closers of restaurants used to do is they would make a deposit in the nighttime after closing, and we typically don't recommend that anymore. What we recommend is you have a safe on site and you put the deposit in it, and the next day, while it is daylight, is when you go make your deposit, because it's very easy for somebody to rob you, walk into your car with a money bag or whatever. Installing small money safes that are very hard to remove or pick is actually not a huge job in most restaurants. Most of them simply put the safe in a big block of concrete. They pour concrete and put a safe with a combination lock on it, and you can get those things out, but it takes a lot of doing. So that's what deterrence theory is. And you also have operational failures. And what operational failures are, it's a pretty broad category, but it can include several different deficiencies in an organization's security program. And this is when the practices, the policies, and the procedures that you have put in place fail. Either because somebody's not following them, because you haven't trained people properly, you haven't supervised them properly, you have not engaged in adequate pre-employment screening, maybe you've engaged in negligent hiring, so you're not hiring good quality people. And really what operational failures are is when all of those things kind of come together simultaneously and end up kind of coming to a head and causing some sort of incident or issue to occur. So those are typically the three major theories behind why you might get sued for premises security liability. Make sure in your textbook that you're reading, you read the sections on officer misconduct, negligent hiring practices or liability, and also about ways to reduce the risk. I mean, honestly, we've already talked about all of that throughout the previous chapters in the text. Realize that many liability claims stem from misconduct on behalf of the security officer. You know, make sure you're familiar with the types of misconduct. People are human. They make mistakes. Sometimes they make mistakes on purpose. You don't always hire the perfect person, and especially when you can't pay them much more than minimum wage, you probably don't get the quality of person that you would get if you were paying them, 20 or 25% over minimum wage. So sometimes you get officers who steal, officers who assault, officers who will lie. It happens. And when you're hiring these people, you have to take steps to reasonably assume that these people are good, decent people. You can't just say, well, this person came in, I like him, so I'm going to hire him. You have to take some reasonable care to avoid hiring potentially bad employees. And maybe you give them a psych eval. Maybe you call their references. You do background check. You call their previous employer. There's a limit to the type of questions and what you can ask previous employers and references. But one of the things I always ask if I was going to hire a police officer, I'd call and I'd talk to their previous employer. And one of the things that I oftentimes would do is I would ask them, I said, if you had an opening and this person applied and they had worked for you in the past, would you rehire them? And sometimes they're kind of evasive, and sometimes they're not. The ones that are evasive, they're the ones that's trying to get by without telling you they would not hire that person back, but they don't want to take on the liability themselves for bad-mouthing somebody. In many times in those cases, I asked the employer, I said, would you mind if I called you when you weren't at work? Would you mind if I talked to you off the record about this person based upon my own observations of this potential employee? And and sometimes they say yes, and I've called them back when they weren't at work, when they were on their own time, and we can have a more frank and earnest discussion. Now, unfortunately, you can't necessarily use that, or you can't report that if you don't hire the person. But honestly, remember that in most states, or in many states, it's an at-will state, which means you don't have to hire somebody even if they're qualified. You can pick who you want to hire regardless. And you also have the ability to terminate anybody for any reason or no reason. Maybe you just don't want that person working for you. If you just if they give you the willies, make the hair on the back of your neck stand up because there's something off with them, then you can. If you work in an at-will state, you can terminate that employee. And just don't give them a reason. Just say your services are no longer needed, and you can hire somebody else. I mean, that happens all the time. You just have to make sure to check the laws in your state to determine if it's an at-will state. Now, I know Tennessee is an at-will state. I'm not sure about Alabama because I've never hired anybody in Alabama. Okay. Excuse me. What can we do to reduce risk? One of the major things we can do is to evaluate your program. That is key. Look at your program, determine what's working, what's not working. You need to make changes and adjust so that it does work, or figure out a different way of doing something so that it does work. Analyzing your program. This is looking at it from an ongoing perspective. Continue to analyze your program. Be familiar with statutes, ordinances, regulations having to do with employment and liability and security. Be familiar with the national security standards. Those are in your textbook. Know the difference between standards and guidelines. Realize that standards must be met. That's minimum things that must be done in order to ensure safety. A guideline is simply a suggestion or a best practice that, hey, this has worked well with others, so it'll probably work well with you. And make sure that you are conducting fairly routine or at least regular risk assessments. And I'm not going to go back into risk assessment because you already know what that is, but conducting risk assessments in an ongoing manner are very important, very important. So all of these things are things that will help you reduce your premises security liability. Providing a safe location for your employees to work, and a safe location for the public to come onto the property. So if you have any questions, please reach out. We are cruising in toward the finish of the course, and I'll see you in discussions. Bye-bye.